So now I'm going to be handing things over to our moderator today, Angela Rapp-Kennedy, CQL's Vice President of Training and Learning Initiatives. And Angela will introduce Morgan and then get us started with your registered questions. Angela.
Thanks, Seth, and thanks for everyone for joining us. It's a busy time of year, and we know your time is valuable. So excited today to have Morgan with us. This has been something we've been working on putting together for quite a while. Before I introduce Morgan, I just always like to remind people who CQL is, in case you don't know us. I'm assuming most of you do. That's how you found this webinar. But we always like to keep our vision and mission at the forefront. For any of you who maybe don't know us as well, Seth will drop a link into the chat box for a short little video clip, a little animated video about our history and who we are. So that's always helpful. I think it's helpful for people if you're going to spend an hour with us to know kind of where we're coming from. So that's us. So we're going to start off with hearing from Morgan a little bit. We have started this series called Ask the Expert, and we've had a couple of different sessions of that already. And so Morgan is our expert today about supported decision making. So Morgan, tell us a little bit more about yourself and kind of your background in this arena.
Thank you so much, Angela. So I'm currently the Director of Supported Decision Making Initiatives at the Center for Public Representation, which is a national legal advocacy center that's really committed to protecting and advancing the rights of people with disabilities. We have staff around the country. I work in our DC office, and I would say I first got involved with supported decision making around 20 years ago when I worked for a federally funded protection advocacy organization as an attorney. And part of that work was to represent people with disabilities in guardianship proceedings and in accessing less restrictive options, including supported decision making, although we didn't call it that back then. I later was a long-time legal director at another organization in DC that advanced the rights of people with disabilities, and I was involved in the representation of the first DC resident to successfully have their guardianship terminated in favor of supported decision-making, and later the first DC senior to have that as well. So we were continuing that kind of work that I'm very passionate about. And I'm the former lead project director of the National Resource Center on Supported Decision-Making, where I got to know CQL very well. So I have published a number of articles and national reports on this and had the opportunity to testify at a congressional hearing on the topic of advancing supported decision-making and guardianship reform. I really am excited to be here as considered an expert, but I really consider the experts in supported decision-making to be the people with lived experience. And so I do hope we kind of keep that in mind as we work on this and talk about this today.
Thank you, Morgan. And just to sort of set the stage for people today, this is really just going to be a conversation between Morgan and I, some questions. Some of you posed questions when you registered for the webinar. Some of them are questions we just know people are interested in. And so we do have a few slides, but they're really just there to a placeholder for the topic, the area that we're talking about. And before we get on to our first set of questions, just want to give a shout out to the Center for Public Representation for supporting Morgan to be involved in this, and we really appreciate that. So we're just going to start off with, what is this? What is supported decision making? Kind of give us the groundwork there, Morgan.
So, we're seeing more and more states adopt formal definitions of supported decision making, and the model law on guardianship has a formal legalistic definition, but I really like to talk about supported decision-making practically. It starts with the idea that people with disabilities and older adults can make their own decisions with the help of people that they choose, to get advice, to be able to get information about the decisions that they face, to be able to talk through issues and questions that they have in ways that they understand, and then communicate those decisions to others. So I see supported decision-making as really what we all do every day. None of us make decisions in a vacuum. We all use the support and advice of people that we trust to make the decisions in our lives. And I think maybe we give supported decision-making a special name in this context just to remind us that older adults and people with disabilities should have that same kind of opportunity too, that they may need different kinds of supports to be able to make their own decisions, but they too shouldn't be judged differently in making decisions and should be allowed to lead self-determined lives. So, I think supported decision-making is human decision-making. And if we normalize it that way, I think it can gain broader acceptance in the community.
Great. So let's talk about all these different options. So kind of talk to us a little bit about, people always want to know the difference between supported decision-making and guardianship, and, rep payee, power of attorney, kind of how does it fit into that kind of continuum?
Well, I would call supported decision-making to be kind of the least restrictive form of support for someone, because it's the person with a disability, or the older adult in this case, who is making their own decision, who's in the driver's seat of the decision-making process, who's deciding who supports them. It doesn't involve the courts. It doesn't involve that. It can be formal or it can be informal. Some people like to put supported decision-making arrangements in writing to promote enforceability. Others, far more people use it informally. So it's a very kind of flexible tool that can be used. People can cancel their supported decision-making arrangement without having to get any formal approval from anyone to do so. So that's why I would consider it kind of, when we talk about that toolbox of supports, it's the kind of the lightest tool in that toolbox. Guardianship, on the other hand, I would argue is the heaviest tool in that toolbox. And while it can be needed in certain kinds of cases, we really do need to recognize it as that heaviest tool because of what it does to someone's legal rights. It means a court has taken that person's legal rights and given another person, a guardian, the authority to exercise those rights in some ways. Now, guardianships can vary in scope. They can be very narrow over just medical decisions or financial decisions, or they can be very broad. But it's really the court that's in charge in those cases. And it's the court that decides whether the guardianship's changed or modified. It's the court that's overseeing the process, and the court really becomes part of the person's life going forward. And so in that sense, it really is the heaviest tool in there. Now, when we talk about other kinds of tools, like powers of attorney, like representative payees, I think it's helpful to think about things that are voluntary versus involuntary. So powers of attorney are another legal tool that can be used for a person, including people with disabilities and older adults, to pick someone to make decisions for them. So they're voluntarily picking someone to make decisions in certain circumstances for them. It could be over certain areas of their life, like finances or healthcare. It could be under certain circumstances, like it could go into effect immediately, or it could spring into effect only when the person can't make decisions on their own. So they're these flexible voluntary tools that the person can cancel. If you can make a power of attorney, you can break it. And so there's that's another kind of tool in that toolbox. And representative payees are another form of substitute decision maker, in that it's someone else making financial decisions around Social Security benefits for the person. In the case of representative payees, it's the Social Security Administration that makes a determination whether or not a person can manage their own benefits or direct the management of their own benefits. And if they can't, they appoint someone else, a representative payee, to act for the person. And in that sense, it's the Social Security Administration that's overseeing that relationship. And that's, so in some ways that can be considered to be an involuntary one. It's not the person that's in control over who is the representative payee. It's really the Social Security Administration. So those are just some, when we think about that toolbox, I like us to be thinking about the different weights of the tools and how to use them. And you can use them simultaneously too. Sometimes people can use a supported decision making for healthcare decisions and have a representative payee for Social Security benefits, or they may use supported decision making for healthcare, but they have a durable power of attorney for healthcare that will spring into effect if they can't make decisions. So you can use these tools simultaneously. It's all part of a toolbox.
And you used a term there, substitute decision maker. Tell us how you view that term, because I hear people use it in different ways sometimes.
It's used in a lot of different ways. So when I'm using substitute decision maker, what I'm meaning is someone else is making decisions for the person. Someone else is signing on that dotted line for the person. So substitute decision makers, in the way I use it, could include guardians. They could include powers of attorney, agents under a power of attorney that sprung into effect. They could include, in some states have laws that have healthcare surrogate decision makers that are substitute decision makings for the person, and representative payees, or someone else is making financial decisions about Social Security benefits for the person. If you contrast that with supported decision making, in supported decision making, it's the person that's making the decision for themselves. Now, they may be getting help to make that decision, but their supporters aren't making the decision for the person. It's the person who's, quote unquote, signing on the dotted line.
And that's a great sort of segue into our next topic of kind of the how-tos. So talk to us about how there's a variety of questions here, but so first of all, what's the process for instituting supported decision making? And you mentioned that it can be formal, informal, legal, not legal. So sort of just tell us, how might you go about putting supported decision making in place?
Well, I think supported decision making is a very individualized type of practice. So it really depends on the person. And there's not a one size fits all when it comes to supported decision making. I've seen people who really want to have a formal supported decision making arrangement where they put everything in writing and all the responsibilities of the supporters and what decisions they do and don't want help with and how they want help. And they put that all in writing. And I've seen very informal ones where people just use, for example, a HIPAA or healthcare privacy release form just to authorize providers to release information to the supporters, and the person can make that decision that way now that their supporters have the information that they need to do. So there's many different ways to put a supported decision-making arrangement in place. We are seeing more states adopt supported decision-making agreement legislation that creates a kind of form. Just as you have a power of attorney form, you have a supported decision-making agreement form that people can use to kind of document those kinds of arrangements. And, as we see more, we have 20 states plus DC have those kinds of arrangements. And so we're seeing more supported decision-making arrangements in writing. That said, as I said, most people use it informally. And I say, how do you put it in place? You have to remember who's in the driver's seat. So it's the person with a disability or the older adult who would want to make their own decisions with support. They would be the ones that pick their supporters. Supporters wouldn't be assigned to them. They would pick who they trust to make decisions and with what kinds of decisions. When we think about decision making, it's a very nuanced and very broad kind of area. And people might want different kinds of support in different areas of their life. So someone might want to have their mom help with healthcare decisions, but they don't want their mom to talk about relationships with her. They'd rather talk to a friend. And so really thinking about it very carefully. There are some great guides on CPR's supported decision-making website that kind of guide teams and how to support people in deciding what avenue they want to go with in kind of forming a supported decision-making arrangement. And I really encourage you to take a look at that.
And I think that's a great reminder for me to mention. We've partnered with Morgan and have done one and are working on a second capstone newsletter. So for those of you familiar with CQL, we do pretty much a monthly newsletter on a different topic with resources and information. And so in November, we did part 1, and there's just an enormous amount of resources involved there. And then in January, you'll see a part 2. The part 1 was more sort of the big picture, high level. And then the part 2 is going to be really the kind of nitty gritty, getting down to the details and hearing from people about how that works. So that's a fabulous resource. And all the links that Morgan's talking about are embedded in that newsletter. So you can really read. And those are all free on our website. So feel free to go look for that. So Morgan, you talk about setting up supportive decision-making, really, the person is in the driver's seat. Talk to us, because we hear people talk a lot about those folks that we know who maybe don't use words to communicate. Kind of how do you suggest approaching that, or what are your thoughts about that?
Well, I first think we always should come to that kind of place of challenging ourselves. What are we doing wrong in terms of communicate? Everybody communicates. Everybody communicates through behavior, through other kinds of ways, even if it's not words, to communicate. And so I think that's what, when I meet with someone and I'm saying, I'm not sure they are understanding what I'm saying, or I'm not sure that they are able to legally understand this kind of decision that they face, I ask myself, what am I doing wrong? How can I communicate differently with them? So I think it's first getting to know the person really well and knowing how they communicate, and then figuring out how to connect that with decision making. And it can be a process, you know. I think, do they need to have access to augmentative or alternative kind of communication devices? iPads can be very useful in communicating with people who don't use words to communicate. So really challenging ourselves there first, rather than assuming substitute decision making or a guardian is necessary. So I would say that's the first space. You really do need to have a reliable communication process with someone in order to be able to effectively use supported decision making and make sure that third parties, like doctors, like schools, like providers, honor those persons' choices. I've worked with many people who don't use words to communicate, who've been able to successfully use supported decision making.
Perfect. And that absolutely is certainly our set of values at CQL, that communication comes in many forms. And sometimes it takes a lot more work, but it's there.
And it's worth it. It's worth it to put that work
in. Absolutely. And of course, I'll put our unabashed plug in for the personal outcome measures, a fabulous way to find out more about people and what they want. And again, all free resources on our website if you want to know more about that. So, of course, the next question that comes up, Morgan, is what about those people who already have a guardianship in place? How can we make that or begin to look at that transition, moving away from that guardianship to a more supported decision-making model?
Well, one of the things I want to first highlight is that when people are within a guardianship arrangement, you know, supported decision-making principles involving that person in their decision-making, the guardian listening to the person's wishes, should be part of that guardianship arrangement. And that's been recognized by the National Guardianship Association. That supported decision-making is traditionally thought of as an alternative to guardianship and should be explored before guardianship is pursued. But its principles should also be used within the guardianship if the guardianship is in place. And I really would encourage providers to remember that. Remember that best practices are that guardians involve people with disabilities and listen to them in their own decision-making process. Now, how you terminate a legal guardianship, it varies. The processes varies by state. You know, it's really governed by what the law is. You usually need to bring in evidence that something has changed, that the person is able to make their own decisions, or that a less restrictive option is more appropriate for the person or can meet the person's needs. So it does involve going to court to terminate the guardianship. And it can be hard to terminate guardianships. You have to kind of be showing, you know, judges don't like to hear, oh, we were wrong in pointing the guardianship. So you really need to make sure you're bringing the evidence to the table about the person's ability to make decisions and or use alternatives to guardianship. It can be very helpful to have legal representation for the person in doing so, but I really want people to think about restoration of rights cases, which is what I call guardianship termination cases, as an interdisciplinary process. Providers and service professionals are enormously helpful in trying to help gather that kind of evidence for people. And it really is a team approach that's the most successful in doing these cases in my experience. So, you know, while it can be hard, it can be done. And I really think we need to think about, you know, guardianship shouldn't be something that's forever. It's a very powerful tool that may not be needed forever. People's abilities change over time and capacity builds over time, regardless of diagnosis and IQ, particularly if people are supported and being engaged in decision-making. Let's revisit guardianships periodically with the support of people's networks and see if we can restore people's rights. So that's kind of, so while you can use supported decision-making within guardianship arrangements, and you should also think, is guardianship needed anymore? And can we support the person in seeking to have it terminated?
And, you know, this isn't a time to get into all the nuances of guardianship, but would you just talk a little bit for folks about the difference between limited guardianship and, you know, full guardianship?
Absolutely. So limited guardianship means that it's not over everything in the person's life. Limited guardianship means, for example, like it could be a medical guardianship where if the court determines the person can't make their own healthcare decisions themselves, they appoint a medical decision maker for the person. And you contrast that with plenary or general guardianship, which the majority of guardianships are that way. And it's over a lot of parts of the person's life. That said, guardian's authority, even under plenary guardianship, is not unlimited. And I think there's a lot of misunderstandings about that. State laws usually prescribe the kinds of decision-making guardians can make for the person legally. And I think when you think someone's under guardianship, don't assume they have a carte blanche to make all decisions about every little detail in someone's life, because they have the authority to make certain legal decisions for a person. They shouldn't have the authority to decide what they wear that day. So, we're seeing more trends towards promoting limited guardianship, but we need more work in that area.
Fabulous. So if I'm listening to this conversation today and I'm a direct support professional, I'm a, frontline supervisor, what can I do? Kind of what are the next steps for me if I want to help support someone to explore this concept of supported decision making?
I think it's about talking to the person about it and educating them about decision making and what supported decision making could mean for them. It's about trying to connect them to the community. I frequently get questions, what do you do if someone doesn't have a lot of supporters in their life or any supporters? Well, what we do know, nobody says, nobody should think that guardianship makes people automatically safer. I've not seen any studies that have shown that. What makes people safer are people. More people involved in their lives, more connections to the community. And so if someone doesn't have the supporters that they need, or not a lot of supporters to serve as checks and balances to each other and keep them safer, why not try to be exploring making those kinds of community connections? The very connections that direct service providers are doing every day to try to help people engage in their community. And so I think those are kind of the first steps, are talk to the person, identify what their kind of support team is and how it can be augmented with the person's permission, and then building those helping people to build those trusting relationships with other people in the community. Those would what I say the first steps of this are.
And that's a perfect segue into our next sort of group of questions, is really about supporters, this support team, who should be on the support team? How big should it be? What's the mix of people on it? How do I get it? All of those questions.
And they're great questions to ask. And I want to first just remind people that it's not about us setting up supported decision-making teams for people. It's about helping the person pick people they trust and build those trusting relationships for them to create the supported decision-making team. So I think we always have to remember who's in the driver's seat in doing this. And I think, supported decision-making teams can look very different depending upon the person. There are people who rely more upon professionals to be their supporters, or staff to be the supporters, because perhaps they have a history of institutionalization, or they don't have that kind of those family networks that are robust in their lives. And so I think that's the kind of, when we're thinking about how do we recruit supporters into this, make sure the person's in the driver's seat, that they're not being assigned supporters, they're actually picking people they trust, and help them build the supported decision-making team over time. So I worked with a young man who has autism, who started with a very small supported decision-making team. It was just his family members. In fact, it was just his parents. And then it later became his brother. And then he met more and more people as he became more involved in the community, and it became, trusted professionals in his life. And it became his, he was involved in church and became more involved in church, and church members started to be part of his team, and his team grew and grew. And some were formalized supporters, and that it was in writing, and some were more informal supporters. And so that's really what we want to see over time. It's not static supported decision-making arrangements, but ones that are building in diverse checks and balances, because that's really what's going to keep people safe.
So kind of talk about the role of the supporters in this scenario.
So, supporters should want the person to make their own decisions, okay? They should understand that they as supporters do not make decisions for the person, and they should really try to guard against, and it can be hard, but guard against coercion or trying to kind of force the person to make the decision that they think is best. They should expect disagreements, and they should honor the person's choice and recognize and help the person learn from quote unquote mistakes that they make in their life, because that's how you build decision-making skills. We all make mistakes in our lives and learn from them, and people with disabilities should be given that opportunity as well. I think that supporters should recognize that the person is the one who decides how they want to be supported. And I think that's another piece of this that we need to think about. There is an ethics to being a supporter in a real way. You need to kind of check yourself. And it's hard. Try to think through, do you have conflicts of interest? And when I say that, we all have conflicts of interest. Parents have conflicts of interest between being a supporter and being a parent or a mother or father. And so we all have to recognize those. We have to educate the person about those conflicts of interest, and then they can make an informed decision about how they want to be supported. So should a direct support professional be someone who is heavily involved in a decision about who is the person's direct support professional? Probably, I mean, that's a conflict of interest, right? If you want to keep your job. So you should be bringing in other supporters to help with that kind of decision to make sure it's really the person's decision as to who supports them. And so I think those are some of the ethics I would describe when I describe supporters in those arrangements. You know, you have to realize that this is a real relationship of trust that you want to honor. And you really want to be upfront with the person about, you know, both what you think about certain decisions, but then realize they may not agree with you and they should be able to make the decision that works best for them or that they think will work best for them. And if it doesn't work out, you can help leave room for mistakes is what I always say to people. I think sometimes when we talk about choice, we say, okay, they made the choice, we wash our hands of it. That's not what a real supporter does, right? A supporter makes room for mistakes and helps the person pick up the pieces of those and learn from that kind of mistake.
And again, we have some great resources on our website around the dignity of risk and about something we call the 3 E's: education, experience, and exposure, that all obviously lend themselves to helping you kind of think about that. So this team of supporters, what happens when the supporters disagree with each other? So the person's looking to this team to help them make, you know, decisions or get their thoughts. And how have you seen teams handle that when there's disagreement amongst the supporters?
Disagreements are going to happen. Okay, that's the human state of being. Disagreements happen, and I think it's about the supporters reminding themselves who's in charge, and that's the person. So they can be offering kind of competing recommendations to the person, and they need to support the person in deciding which ones they're going to be picking. I think this can get particularly complicated with family dynamics, and there's no special magic pill for dealing with family dynamics in doing this. I think a supported decision-making team is one where we allow everybody to be heard. We respect the person, but we also respect the supporters and their involvement. And we really help the person choose among options that might be offered to them, and understand disagreements will happen. There's a real difference I want to highlight here between supported decision-making and what I'll call shared decision-making. Shared decision-making is an idea that there's consensus. A decision is made when there's a consensus of the team, including the person. Supported decision-making is not that way. There doesn't have to be a consensus. It's the person who gets to decide what's going to work for them and what they want to make. And in that way, it's different than this idea that the team has to agree all the time.
That's a fabulous clarification. I love that difference between supported decision-making and shared decision-making. Yeah.
You know, Angela, I call it the curse of too many SDMs, because we have substitute decision-making, we have shared decision-making, we have supported decision-making, and there's all these SDMs out there. And so I think it's important to understand how they're all different from each other.
Excellent. Yeah, just more for us, our brains to wrap around. So let's talk a little bit about people having these decisions recognized. And, you know, obviously with guardianship, there's a piece of paper you can, you know, show to some doctor or the hospital or the ER or whatever, or the bank. So how do people go about having kind of those formal institutions in our lives, banks and hospitals and doctors, recognize these decisions?
Well, you know, as I said, there is this movement towards creating formal supported decision-making agreements in state law. So we are seeing more states do that, and it gives another avenue to kind of promote enforceability in a real way. Because usually those legislations, although the legislation varies by state and has different rules about who can be a formal supporter, you really should look in your state law in those cases, if you're in one of those 20 states in DC, about what the rules are for you. But they can help with enforceability. Another real piece that can help, though, is that supported decision-making has been recognized by the Department of Health and Human Services as a reasonable modification for a person with a disability. In other words, it's a way in which you can avoid discriminating against people by allowing them to have this access to supported decision making. And if you don't let them have access to it, it could be considered discrimination under Section 504, which is a federal law governing this, as well as the American with Disabilities Act. And I've been really happy about this formal recognition for a number of reasons. One is that it really helps enforce supported decision-making arrangements across state lines. So people might get healthcare in different states. You might live in a state that has a supported decision-making agreement, but next door is a state that doesn't, and that's where you get your healthcare. And so you can say, well, this is a reasonable modification or accommodation for my disability, honor my arrangement, or you could be unlawfully discriminated against me. So, I mean, that's one way of enforcing that just more broadly. And it can also help people who don't have formal supported decision-making arrangements, who use it more informally to be able to enforce that arrangement. And when I worked in DC, before DC had passed a law, I used that. I used the argument of the American with Disabilities Act. This is a reasonable accommodation, and was able to effectively enforce what were supported decision-making arrangements. I think another way to enforce arrangements is to really recognize the why of things. So, I think that the health privacy law, HIPAA, with that federal rule, as well as in education, it's called FERPA, can be used by medical providers and schools as a weapon against supported decision-making. Oh, I can't talk to you, mom or provider, because of the health privacy laws, because of HIPAA. That's easily overcome by the person with a disability or older adult signing a release of information form, a HIPAA release form. All providers have it. What is the level of capacity needed to sign one of those? I want that person to get information about me. It's a very low level of capacity to sign those forms. And I know there are states that haven't passed formal legislation where advocates have kind of created a supported decision-making agreement by just making a fancy HIPAA form. And so that's another way of trying to enforce it regardless of you don't need a change in state law to be able to use it. You can use it as an accommodation for a disability, or really look at the why and use release of information forms strategically. I think those are really important ways. And I think the final way, I've heard stories of providers sharing with me that, oh, the doctor says they won't treat the person if they don't get guardianship. We have to recognize that for what it is. It's discrimination, okay? You can't, solely based on someone's diagnosis, you can't make a determination that they can't provide informed consent for healthcare. And so you have to have better reasons than that. And so I think pushing back on providers and looking for on healthcare professionals and looking for other healthcare professionals who might be willing to honor the person's choices are really key here. And, don't be afraid to get, protection advocacy systems involved if it's needed to enforce the person's right and if the person is being denied healthcare. I think a really good example of this that, we really saw a lot of, DSPs step up during COVID, when there were really strict restrictions on who could be in the hospital with someone, right? Because of COVID. And, people needed their support. They needed their supporters, in-person supporters with them in order to be able to get equal access to healthcare, either help communicating or help being able to, be there in the hospital. And, there was litigation that was brought around that to say, look, you have to allow, supporters in there when they need it for accommodation for their disability. And it took a fight. And it was successful, and laws changed and rules changed in hospitals. And so it is possible. And I think it's all of our jobs to make sure that people's ability to make decisions and get equal access to services is enforced. That's their right.
Do you have any examples or thoughts more specific to the financial world, to banking and, all the credit cards, all those kind of things?
I think those are I think I get a lot of questions about banking, in part, like people concerned banks are not going to honor arrangements. Mm-hmm. And I think we have to first acknowledge that there's a thing called financial abuse. Okay. And banks are regulated and mandatory reporters, meaning they have to report if they believe there's financial abuse. And that's true regardless of the arrangement that a person is in, be it guardianship, be it powers of attorney, be it supported decision-making. We also have to realize that banks and financial institutions are risk adverse, as many are. However, they too are capable of discriminating against people And so we have to be willing to push back on banks too. I one time during COVID, so I couldn't help get the person, help notarize a document for a person that I was supporting who had Down syndrome. And the bank refused to notarize a document for her because of Down syndrome, not because they'd had any conversation with her at all. And that's discrimination. And so we had a hard conversation over the phone. So be willing to push back on banks as well in these kinds of cases. Now, I think there are many ways to use supported decision-making with money. There are many kind of protections you can put in place, from having, credit cards that have limits, to having bank cards that have people on it that can see when charges are made. So there's a lot of ways to create oversight, as long as it's with the person's permission, with respect to banks. And so I think thinking through carefully what those options are and educating yourself about all those different kinds of options as a direct support professional and as a provider is a really important piece in thinking of getting people access to money. And even if you're someone's representative payee, you can create certain kinds of arrangements where people get experience with budgeting and build that skill over time when we talk about supported decision making.
Absolutely. And I haven't looked at the chat box, but Seth is always on top of things. He's probably already dropped a link in there. We did a capstone not that long ago about finances and how different ways you can support people to be more independent and financial management in their life. So, and you've sort of answered this, but I just want to ask it more specifically. So what about when people refuse to recognize supported decision making? It sounds like part of it's education, making sure they understand they potentially are breaking laws with the Rehab Act 504 and ADA and those sorts of things. But what's been your experience in being most effective?
I think characterizing supported decision making as a reasonable accommodation puts it into a framework that third parties like banks and doctors are more familiar with. I think people are more familiar with the American with Disabilities Act and those kinds of rules than you think they are. And so framing it as I'm asking for a reasonable accommodation can be a very effective way of doing that. Even if there's a supported decision-making agreement, even if your state has a law about it, maybe that third party doesn't know about that law. There's a lot of education that needs to be done there, and these laws are relatively new. So kind of putting in that framework, knowing that that's been recognized by the feds as a reasonable modification accommodation for people, can be a very helpful enforcement tool. Education, of course. I think educating people and kind of defending people's rights is a role we all have in supporting people in the community, and expecting pushback and not letting it totally dissuade you from continuing to fight. Supported decision making, is still not known by a lot of people, and you're going to have to do that kind of education and fight on this. And unfortunately, ableism and ageism are alive and well. And so being willing to do that kind of education repeatedly for people, and not assuming that just because it's hard just because you're facing some pushback means you have to go the guardianship route. It's just not the case. Guardianship is a very powerful tool that's overused in the United States.
And again, perfect segue into our next sort of set of topics about education. So people are real curious about how can we go about educating a whole list of people, the folks we support, their families, banks, healthcare, doctors. We've talked a little bit about that. So what are your recommendations for beginning to really share this information in a useful way with people?
Know your audience. The messaging around supported decision-making needs to be tailored to the audience. And I've done a lot of presentations for families. I've done presentations for doctors. I've done presentations for financial professionals, for service providers. And the messaging is always different, okay? And I think that's a piece to kind of be thinking about. When I'm talking to families, I find it very helpful to talk about the benefits of self-determination. That research has shown that people with disabilities who have, greater control over their lives and are actors in their own life have better life outcomes. They're more integrated in their community. They're more likely to have a job. All of these kinds of very pieces that I know, CQL looks at very closely. And I think, talking about to families about what are you going to do when you're not here anymore. It's a hard conversation to have, okay, but it's one that needs to be had. You know, how are you going to be able to build those networks? I think that peer-to-peer education can be the most successful. So when I give a presentation to families, I present with a parent who uses supported decision making. And there's some really great videos from parents on CPR's SDM website that talk about, you know, what it means to them and how they evolved over time and how they thought about decision making. And I think that can be very helpful. And then hearing from people with disabilities themselves who use supported decision making can also be the most powerful of tools in providing education. And there's some great videos and even more stories about this. And that's why I'm so excited that CQL is going to be having in its January issue highlighting some of those stories. Because, I mean, I have found in my efforts to provide education, it's those lived experience stories that are the most effective in convincing people that's to give supported decision making a chance.
Perfect. And so education sort of runs over into tools and resources as well. So where do people access this, this material? So if I'm somebody and I'm wanting to educate the people I support, where am I going to find some resources, or who can do that for me? Same thing for families and that sort of thing.
So I included some great resources that I found in the article that we wrote together for Capstone. And I really encourage people to take a look at that. There's, I mentioned CPR's supported decision-making website that's been put in the chat by Seth, which is very helpful. There's also some great videos called Georgia, I Decide Georgia, which has some great videos geared to families, geared to professionals that we've also contributed to. There's the Center on Youth Voice, Youth Choice was one that I included there too, which has some great videos for family members and an even training series that focuses on family members. And they have some useful kind of one-pagers, sometimes that could be useful for families. One of the things I think is most powerful when we talk about education, there are lots of myths about guardianship and supported decision-making that exist out there. And I think, and so there is, for example, a handout that Civic created that the Center on Youth Voice, Youth Choice created that really focuses on dispelling those myths. That guardianship doesn't automatically make you safer. That, that guardianship is easy to terminate. All of these kinds of things that are out there to really try to encourage people to think hard before making those kinds of decisions and really know what your options are so you can make the informed choice with the person. And so those are a couple of really good resources that I've found that have provided very accessible ways of education. And there's some plain language materials at those resources as well, which I think, is always helpful. Everybody likes plain language. And so I think really look at the tools, don't recreate the wheel. There's a lot of tools that exist out there.
And what about tools like in the form of examples of a SBM agreement? Or different forms that you've talked about? Where can people kind of look for that potentially?
Well, I linked to some of those in the Capstone article as well. First, I think you need to determine, are you in a jurisdiction? Are you in that state that has a particular supported decision-making agreement form you're supposed to use? Because you want to use that form if you need to, if that's the only way it's really going to be legally enforceable in your state. Or if you want to make it easier to be legally enforceable in your state. So, on CPR's website that's linked to in the Capstone, we have a list of of the states that have supported decision-making agreement laws. So take a look at that, because that might kind of dictate what your form looks like and who your formal supporters are. We also have examples of model supported decision-making arrangements. So say you're not in a state that has one of those kind of formal laws, but you want to create a supported decision-making agreement, you can do so using some of those kind of models that are out there. And then, I also think really thinking about, does the person want to have an agreement that way? I think when we think about that, we really need to think about cultural considerations. Not everybody wants to, formalize what they consider to be this natural family relationship or some kind of natural relationship in their lives. Some are concerned about legal documents because it triggers those kinds of concerns and all those kinds of things because of their culture, how they've been treated. And so really trying to think, it's not a one size fits all. You don't have to have an agreement to use supported decision-making, and most people don't. So I encourage you to take a look at those forms. They can give you some ideas about how to use that.
Perfect. So let's see. So the best way for folks to find out kind of the status in their state is to go to the CPR supported decision making link that we've got, and then you've got the list of the states and
Yeah,
who's kind of
that's
doing
one
what.
way. Another way is, the National Resource Center for Supported Decision Making has a website and a map. So that's supporteddecisionmaking.org has a map that also lists laws. I don't curate that anymore, so that's the reason why I'm focusing on CPR's resources, but I'm not trying to disclude those other resources that are out there. We periodically at CPR update that list to try to kind of create it. And different states have legislated supported decision making differently. So while I said that there were 20 states plus DC that have supported decision agreement legislation, some states have recognized supported decision making, for example, during transition age conversations in school, and some have recognized it as a reasonable accommodation in certain medical contexts. And so that page has lists, even though you might not be a supported decision making agreement state, your state might have recognized supported decision making in other ways that could be useful in your advocacy. And so the page on the CPR's website has those listed as well.
Great. Let's see. Before we've got a lot of questions coming in that we'll start fielding some of those. Before we do that, Morgan, I think it would be helpful, just as you mentioned, and this isn't something, I apologize, that we talked about beforehand, but could you share an example, of where you've been involved with someone who has been able to put supported decision making in place, and that's been very successful, and sort of how that worked, and sort of pick one.
Exactly. And I'm going to actually pick an example. I think sometimes there's this myth about supported decision making that it's only for certain people with certain kinds of disabilities. I've worked with people who have who have a variety of different disabilities, from intellectual disabilities to psychiatric disabilities to memory loss and dementia, and who have successfully been able to use supported decision-making arrangements. And so I'm not going to pick the lowest hanging fruit when we talk about this. I'm going to try to I'll pick somebody who doesn't use words, uses a speech device to communicate. And so, I worked with someone who was really trying to plan for their future, and they used communication device to do so, and they actually used facilitated communication, which is sometimes controversial, and you have to think really carefully about that. And I got to know the person really well. Okay, I used different kinds of facilitators in there. I did my homework on the person and got to know them better, because they didn't know me from anybody. That's how we started the conversation. And he had very clear wishes about what he wanted for his life. He had very clear wishes for who he wanted to act for him if he couldn't act for himself. And we worked hard, and it took a number of months over time to really develop this supported decision-making arrangement that was going to work best for him. And having him understand that he was in the driver's seat, even though throughout his life, so many decisions had been made for him, his family had always involved him in that decision-making and really had built his skills over time. And that arrangement, when we finally reached it, I was really confident that this was something that he wanted, that this was going to be something that I was going to defend, because I don't help people make supported decision-making agreements if I'm not going to defend it. And, and he was someone who I think a lot of people had written off, as he was going to need a guardian for all of his life because he used this kind of technology to communicate. And so, it goes back to your communication question, Angela. I think really challenging ourselves to say, what can we do differently in supporting people is a really good example. Another example that you can see on link to on the I Decide Georgia website was a young man who got out of guardianship using supported decision-making, who also used assistive and augmentative communication. And it has a story where his parents talk about why they pursued guardianship, how they made that decision, how he didn't have reliable communication in the beginning, and how that changed over time, and how he really wanted to make his own decisions legally. And so, I think looking at those kinds of stories and understanding that the arrangements that support people with decision-making can change over time and doesn't have to be guardianship forever is another kind of message I'd like to send today.
Perfect. So what about there's a question here that, and I'm not quite sure how to pose it, and I'm not quite sure totally what the person is asking, but something I hadn't really thought about, and how supported decision making might apply in the context of criminal proceedings. Have you had any
Yeah,
experience with
that's a
that?
very complicated question, and I give this answer. We all, people don't always think about this, but lawyers specialize in different areas of the law, and I am a civil lawyer, not a criminal lawyer. But supported decision making, it can get complicated in the criminal context, and so it depends on what you're really talking about here. And so I don't want to predict what you're talking about, but there is, I think when we talk about questions about, for example, competency to stand trial and those kinds of issues like that, it can get very complicated when you're doing supported decision making. If instead you're saying, a comment I get a lot from parents is they got guardianship because they were concerned their child was going to be arrested. Supported decision making, I mean, guardianship doesn't stop people from being arrested. Okay.
Right.
You need to be safety planning for that. Okay. And so I think that's one of the myths I like to dispel. In terms of the criminal side of things, I would have to defer to a criminal lawyer.
Sure. So what about this notion of you're supporting people, giving them input so that they can make decisions, and what you see is they're going to make a decision that is dangerous? So it's that sort of notion about the dignity of risk, and how do supporters in this scenario play into that?
I get that question a lot too.
Yeah.
And I think you first have to ask yourself, how dangerous is it? I think sometimes we assume every little bit of danger is the most dangerous thing in the world, and it's not. Okay. And so first kind of really gauge, what do you mean by dangerous? What's the level of danger that they're making in these kinds of cases? And I think, you also have to decide, what is your role of a supporter? Now, I usually would think a supporter is somebody who is supporting someone to effectuate the decisions that they are trying to accomplish. But you don't have to be so open-minded that your brain falls out in a way. So, I talked to a former boss about this, and she says, you don't have, there's debate about this, I think, within the supported decision-making realm. But, if someone is going to be doing something very dangerous and they've made that decision, you can say it's your decision. I'm not willing to help you with it. You have to be honest as a supporter. And effectually, what is the limits of what you're willing to do for someone? And that's called honesty. But I really think you need to really evaluate to yourself, how dangerous are we talking about? Because I think sometimes we think of every little bit of danger for people with disabilities. It can't, we have to make sure we're allowing for the dignity of risk, is what I'm saying, and allowing for people to learn from mistakes.
Yeah.
There are some decisions that people make in their life that are truly dangerous, and there are some that may have risks associated with them, but they can be remedied.
And I know for us, we talk a lot of times about, kind of a matrix and helping people walk through pros and cons, and, possible consequences and benefits, that sort of thing, and helping people in that way. So we've got one person, and I'm just going to actually quote them because I think it's probably what people are thinking. It says, "Guess I'm jaded." But how is this any different than adults pulling in other folks for certain decisions in everyday life? So if there's not a formal agreement in writing, couldn't just anybody say, "Oh, I'm their supported decision maker"? And I think I want to ask this question so you can clarify again. There are not supported decision makers. There are people who are making their own decisions. So would you talk about that?
Yeah, well, I will. So when I give a training on supported decision making, and someone raises their hand and says, "I'm the supported decision maker for someone," I know I haven't done my job, because supporters don't make decisions for people. Okay, the decision maker is the person with a disability or older adult that we're talking about right now. And so remembering that, okay, there's not a supported decision maker. That's not the language we use, and it kind of confuses what supporters' roles are or aren't. I think it's not the supporters that get to decide, I'm the person's supporter. There'd have to be some clear indication from the person that this is their supporter. And that could be done by behavior. That could be done in a lot of different kinds of ways. It doesn't have to be a formal agreement. But I think we have to, also understand and appreciate that any tool we talk about in that toolbox I mentioned can be misused by bad actors. Okay. Guardianship, we've heard horrible cases of guardianship abuse. I've heard powers of attorney be called license to steal. I've heard, all sorts of things around these kinds of pieces of this. And so what makes people safe is bringing in more people into their lives so that they can be checks and balances for each other. And that's how you create safeguards and supported decision-making agreements. And you should think about how to create those kinds of safeguards to help the person pick how they want to do these safeguards. That's why I like the idea of supported decision-making arrangements growing over time. So, thinking that supported decision-making is somehow more susceptible to abuse than any of the other tools that I talked about, I think is a myth that we need to bust.
Great. Thank you very much. There's a question, and I think it comes up for people, and you've sort of talked about this, but the term competency. How do you think about that concept of competency when you're thinking about supported decision making?
So, competency and capacity and those kinds of terminology that's out there, they're legal constructs. And so, when we talk about those ideas, we have to realize that it talks typically about state law underlying how capacity is defined for people in this. And it's something we need to be considering when we're talking about supported decision making. But I really encourage us to rethink what capacity and competency mean. I don't really like the terms because I think they're misunderstood, but they are legal constructs that exist in state law. So capacity, it's not determined by IQ or diagnosis. Okay. Capacity fluctuates. It's not a kind of all or nothing concept. It's not like you have it or you don't. You can have the capacity to make some decisions at some times and not others. You can have the capacity to make only certain kinds of decisions and not others. You can have the capacity at certain times of the day to make the decision, or only if you get support in understanding the decision you face. So let's rethink about capacity. It's not a black and white kind of idea. It really is nuanced, individualized, and very decision specific. And so that's when you're thinking about capacity and competency, really think about that, about it being very individualized and situation specific.
So we're kind of getting close to our time. We've still got lots of questions. We knew we'd never get to all of them anyway. Really encouraging people to make sure they take a look at the CPR, Supported Decision Making website, to look at our capstones. We wanted to really highlight this report. Maybe Morgan, could you just give us a couple tidbits about this report?
So it touches a little bit on what I talked about, cultural competency around supported decision making. So Center for Public Representation, with the support of the Massachusetts Developmental Disability Council, engaged in a project with key community partners to try to make supported decision making more accessible to underrepresented communities in Massachusetts. And we learned a lot of lessons through this process, which was a very rewarding one, about really, kind of how we should be partnering with community leaders and how we can elevate the voices of those community leaders and people with disabilities and family members around understanding what all their options are before making decisions like guardianship. And so we developed a report that included ways in which to replicate those kinds of ideas and some thought-provoking ways in which we learned over the course of the project how to talk about supported decision-making differently depending upon the community you're speaking to, knowing your audience. So I really encourage you to take a look at the report and feel free to email me with any kinds of questions or ideas for partnership.
Fabulous. And just want to make sure to go to our website. All of the resources are there that we've talked about. Seth will be sending out a follow-up. Somebody asked about, not being able to download what's in the chat. That's all going to come to you in a follow-up email. Seth, do you want to say just a bit about that?
Yeah, absolutely. So we'll be following up with all registrants of this webinar, regardless of if people attended or not, with an email and come out in a couple of weeks. That'll include, as Angela had mentioned, all of the chat links, as well as the webinar recording and a PDF version of the PowerPoint slides. We do encourage you to sign up for our emails if you're not already, so that you receive the part 2 of the supported decision-making capstone that'll come out in January. So please be on the lookout for that.
So Morgan, any last thoughts you want to leave the group with as we sign off?
Let's all start from a place where supported decision making is an option for people. Let's try to start to shift the culture to viewing, instead of guardianship as the default for people with intellectual and developmental disabilities, supported decision-making is the default. And let's challenge ourselves on ways in which to overcome barriers and challenges to doing that. Wouldn't it be wonderful to see that kind of shift? And much more is needed than law change. It really comes down to how we support people and what our principles are in doing so. So please see me as a resource. Please know you can email me, and I'm happy to help or direct you to someone I think can help you. I want to thank you all for your really hard work in this area.
And yeah, I really want to reinforce that. Some folks are saying, well, what about my question? Most of your questions, I really believe, can be covered. You can hear answers to them from all of the links and the resources. And we just can't thank Morgan enough for her willingness to be a resource to you as well. And we really look forward to our continuing partnership with Morgan, with CPR, with supported decision-making resources around the country, because we are right in alignment with Morgan in terms of the sort of the vision we would have for the future for people. And we appreciate you taking the time today, and we look forward to what other resources we can provide to you down the road. So take care and have a fabulous holiday season, whatever that might look like for you.